So yesterday, a judgment was passed on the bail reapplication of accused number 5 and accused number 4 in the AKA and Tibz murder trial. They are applicant number 1 and applicant number 2 in this bail application. So I hope that doesn't confuse you. But you know what? Just in case this is your first time watching a video on the AKA and Tibz murder, I'm going to go ahead and give you a brief summary in a moment, and then we'll jump straight into their bail application. But first and foremost, hello, welcome to Mzansi Unfiltered. This channel provides you with legal analysis on high-profile cases right here in Mzansi. But you know, sometimes we cross the borders and we also talk about other cases worldwide. We do this with a touch of humor, or should I say a sense of humor, as well as adding crazy nicknames here and there. And we also have our unfiltered family dictionary and exclusive emojis for our channel members. So remember, this is strictly commentary. We are not providing legal advice here on Mzansi Unfiltered, but let's go ahead and jump into it. So on the 10th of February 2023, AKA was standing outside Wish restaurant with his friends, and his entourage was standing outside Wish restaurant on Florida Road in Durban. Unfortunately, his life was ended by one of the 5 accused. He fell to the ground and died instantly. And then other shots were fired, and one of those bullets hit Tibz, popularly known as Tibz, AKA's friend, who had just given AKA a hug, and they were saying their goodbyes. And unfortunately as well, he passed away at the scene. So that is what happened to AKA and Tibz on the 10th of February 2023. And then, long story short, a huge investigation was like this. Unfortunately, the video of this shooting was leaked and it played out online. And AKA was a popular rap artist who was well loved within Mzansi, although surrounded by some controversy with regards to the passing of his fiancée, Anele Tembe. But you know what? We'll talk about that in a separate video. But in this video, I want to talk about the bail application and why it was denied. I want to talk about accused number 4, Gwabeni, and accused number 5, Lindoguhle Ndimande, who applied for bail a second time. And the judge had some choice words to say about their second bail application. But you know what? Let me give you some background just in case you are listening into the AKA and Tibz murder story for the first time. So, hey everybody, welcome back to Mzansi Unfiltered, your one-stop channel for the latest updates on stories shaping South Africa. Today, we're diving into the latest developments in the AKA and Tibz murder trial. 5 men stand accused of their brutal killings. Buckle up, this is going to be intense. Now, let's rewind for a moment. In February 2023, the South African music scene was rocked when Keenan, aka Forbes, and Tibelo, Tibz Motswane, were tragically shot outside a popular Durban restaurant known as Wish on Florida Road. What followed was months of speculation, investigation, and finally the arrest of the 5 suspects in connection with their murder, plus an additional 2 who are coined as the Ndimande brothers, who are still in Eswatini. They were arrested in Eswatini. Their extradition hearings occurred in Eswatini, and they are still in Eswatini as we speak. Okay, but back to Durban. So when these 5 men were arrested, plus the 2 Ndimande brothers, their arrests brought some hope for justice, but they've also raised some serious questions. So who are these 5 accused? Let's break it down without compromising legal protocols. These men, aged between their late 20s and early 40s, allegedly have ties to organized crime syndicates operating across KwaZulu-Natal. The prosecution argues that this was a carefully planned hit, the accused each playing a critical role in the execution. it is alleged that accused number 4, who is the coordinator and mastermind, received a deposit of 800,000 rands from Sydney Mfundo. Okay, and when he received that payout, he then distributed it amongst the other accused. So from the alleged mastermind to the getaway driver, the state's case is built on a network of evidence, including surveillance footage, phone records, and witness testimonies. But here's the twist. The defense is calling this a case of mistaken identity. Now, accused number 4 and accused number 5 headed back to court to request a review on their bail application, again based on new evidence. Accused number 4 is a businessman. Okay, he's involved in the coal mining industry. He has 2 wives. If I recall correctly, his first wife is a doctor and the second wife is either a teacher or a student. I cannot remember exactly. And accused number 5 is single, not married, was at the crime scene on the 10th of February 2023. However, he was on an alleged date, so he was inside Pagati, the restaurant, waiting for his date, who is unnamed. It is a lady, so we're going to coin her Ghost Lady. She ghosted him and never showed up for the date. However, the morning of that shooting, accused number 5 opened up a brand new bank account at Standard Bank, and accused number 4 deposited 100,000 rands into his bank account. And it's alleged that accused number 5 is the driver for accused number 4, and the 100,000 was payment for services rendered, past due payments and money that he owed him. He was his driver, and this is the kind of money he kind of paid him for his long distance trips. Accused number 5 is a father of 2. He owns 2 vehicles, okay? And as well, he operated a poultry farm. It is also alleged, I believe, that his girlfriend is an advocate, but she is not the one he was going on a date with, if you know what I'm saying. Okay, so drop a 1 in the comment section down below if you are following what is going on here. So accused number 4, Gwabeni, is alleged to be the coordinator and the mastermind. Accused number 5, Lindawuhle Ndimande, is alleged to be a spotter. He was just in the same restaurant, conveniently, as AKA. When the shooting occurred, he didn't move. Okay, he didn't move. He didn't check out anything. He stayed at his table right there. Nothing fazed him about the shooting. Okay. So they came back to court. They said, listen, our families are suffering. Our families are suffering because we're the breadwinners. We need to get the hell out of jail and prison, because accused number 4 says, my children, okay, are no longer going to school. My kid has been kicked out of private school because we're owing 100,000 rands. My child is also going to see a psychologist. My children miss me. And, I am the breadwinner. But I don't know if they forgot that he has 2 wives, one of whom is a doctor. Accused number 5 says, my financial status has changed. I need to get out of jail. My family is suffering. My children are suffering. I'm the only one who is supporting my children. I need to get out of here because the one of the vehicles that I own, which was a taxi, was involved in an accident. Although the accident wasn't reported to the police because nobody was injured or anybody died. But then the vehicle was abandoned, and, when the police went to track the vehicle, they just found it randomly abandoned. Yeah, so that is literally the summary of what happened. The judge made his ruling, and he said, this is ridiculous, okay? You guys did your first bail application. I said no. You then went to appeal, and the appeals court, they said no. There's nothing, they uphold my judgment. And then you are back? So you guys went to high court to appeal my decision, and you are back again trying to get bail? Make it make sense. Make it make sense, because you haven't presented any new evidence, and not only that, you expect me to overrule a higher court's decision and grant you bail? Make it make sense. How am I supposed to grant you bail when you cannot even provide me with any new evidence? There's nothing new about your situations that I can warrant granting you bail today. Bail was then denied. I mean, it was crazy. I'm going to play the clips for you. You have to hear the judge himself, because let me tell you something. It is a stark difference if you have been following the SENZO MEYIWA trial. This judge is a stark difference, night and day, from Judge Rata, because he outlines exactly why he is saying no. He outlines his reasoning. He outlines his thought processes, and then he gives his judgment. But I'm going to let you listen to that for yourself. So that is it with regards to what happened in the AKA and Tibz murder trial bail application, or should I say bail reapplication. Let me know your thoughts in the comment section down below, and I'll definitely be in the comment section to engage with you guys. Thanks for watching. I'll catch you on my next upload. Here are the clips right here.
Looking at the evidence in its totality, it is the view and finding of this court that the financial prejudice referred to by applicant 2 is self-created for him to allow such a valuable item to rot up. It does not amount to new facts. And looking at the totality of evidence, it is the finding of this court that this court cannot and this court should not assist the applicant, because the facts presented before this court are either not new and they should not be entertained, and applicant's application to be released on bail is again refused. Gentlemen, the matter against you is postponed for indictments until the 7th of February. You are both to be kept in custody. To these facts, which are alleged by both applicants, applicant number 1 further alleges that 1, after the refusal of his bail due to his incarceration, St. Benedict School sent his family a letter of breach of contracting, and alleges that in the event 100,000 is not paid by the 10th of December, then the contract will be terminated. 2, after the refusal of bail, one of his minor school-going child had to attend counseling since August 2024. 3, after the refusal of bail, the school fees of his other minor child fell into arrears at Grace Place. 4, after the refusal of bail, his junior wife had to seek therapeutic treatment because of the traumatic experience she underwent. In his case, applicant 2 further alleges that after the refusal of his bail, the only taxi he has was involved in an accident and has not been repaired due to his incarceration. 2, after the refusal of his bail, applicant number 2 and his family have suffered extreme financial prejudice, as he has not been able to conduct his employment duties and therefore generate income to sustain his household. Both applicants claim that the facts referred to above are different in character and constitute new facts that warrant consideration in the interest of justice. Both annex relevant documentation in support of their respective assertions. The state is opposed to the application. In this regard, the state has verified the alleged new facts and filed an affidavit with annexures by the investigating officer, Warrant Officer Pillay. In his affidavit, Warrant Officer Pillay, the investigating officer, deal with each applicant individually and separately. For purposes of this judgment and brevity, I will, where the facts are the same, deal with them together and jointly. It is the evidence of Warrant Officer Pillay that inasmuch as the investigation has been completed, the concern about the safety and well-being of the witnesses is of much concern, even more so now that the identity of the witnesses will be known. Regarding the Eswatini High Court judgment, it is the state's contention that it undertook to proceed without the Ndimande brothers. The state further contends that inasmuch as the matter is still in the district court roll, but it will be transferred to the High Court on the 7th of February 2025. Regarding applicant number 1's assertion pertaining to school fees, Warrant Officer Pillay states that this fact was raised by the applicant during the initial unsuccessful bail application and refers the court to paragraph 58 of Exhibit F, that is applicant number 4's founding affidavit in those proceedings. Warrant Officer Pillay went on to testify about the strength of the state case, alleging that the state has now secured CCTV footages at the King Shaka Airport for the day of the incident when the deceased, Mr. Forbes, arrived at the airport. He elaborates as to the content of the footage and the detail what is seen in there. According to him, there is a clear involvement of applicant 1 as the organizer and the fact that he played a lead role in the hit. In his testimony, Warrant Officer Pillay further challenges the allegation by applicant 1 that his release on bail will afford him an opportunity to raise fees and consult as an old but reshuffled fact which was raised and dealt with in the initial unsuccessful bail application. Regarding applicant 2's assertion that the only taxi he has was involved in an accident has not been repaired due to his incarceration, Warrant Officer Pillay testifies that this fact was followed on the 6th of January 2025, and certain individuals related to the applicant, he mentioned them by name, were consulted and interviewed in this regard. The leads that were provided by these individuals were followed, photos of the taxi in question were taken and handed in as proof of that fact. According to the brother of applicant 2, the incident happened on the 18th of May 2024, but was not reported to the police as there were no injuries. Proceedings to allow an unsuccessful bail applicant to repeat the same application for bail on the same set of works week in, week after. This was the line of reasoning and the finding by the court in the matter of State versus Farmas 1996, Volume 1, SACR 528, Transvaal at page 531, paragraph E. The court may also not, in the absence of new facts, justify granting of bail, set aside its own earlier decision of bail or of refusal of bail in this regard. And in this regard, see the matter of State versus Waldeck, 2006, Volume 2, SACR 120, Northern NC at page 53. In this matter, I've heard the evidence, whether correctly or wrongly, and I have to make a decision on whether the facts presented before me amount to new facts and therefore justify the release of the accused on bail. May I have the court book, please? Is there a court book? Will you bring it to me in chambers? Okay. Court adjourns.